Mic check, mic check. Good morning, everybody. We should get started here roughly a little bit later soon. If I could have your attention, please. If you are registered to speak, as a kind reminder, please make sure that the light is on this microphone before you begin speaking. Otherwise, no one will hear you on record. And then before you leave the podium, please make sure to mute by pushing the button again and making sure the light is off so the next person can come up and repeat the process. For staff in the room, as a kind reminder, please do not move the microphones away from your mouth so those online can hear you properly. So when you come up to the desk, please make sure that you move the mic as close as possible so we can hear you loud and clear. Otherwise, also, please make sure that when it is your turn to speak that you push the button to make sure the light bulb is on. Thank you.
welcome to the August 20th, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:37 a.m. I'm joined by my colleagues, Bobby Janeka and Katarina Gonzalez, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument and discussion is allowed, we will inform parties in the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the Commission on a particular item, please either visit our registration table if you're in person, or if you're on the webinar, email agenda at tceq.texas.gov with your name, affiliation, and the item you would like to comment on. We will do our absolute best to accommodate the request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking, and please make sure that your line is unmuted before proceeding. Before we get started with the actual official agenda, we are going to recognize some TCEQ employees. I'm going to go to the front to do that. One quick note, I have a new hearing aid, which is really great, and I'm super pumped about it, but I'm getting used to it. So if I am yelling or too silent or you hear static, that is because of my new hearing aid, but I am now the bionic woman with it. So let's get this started. This feels very awkward, y'all. I'm sorry. This was not made for this. This is my favorite type meeting because I get to honor TCEQ employees and family members that have been here for a long time, those that have spent a lot of decades making this agency what it is, and they deserve all the kudos in the world, and this is the least we can do. So Patty Love, are you here? Patty. She's recognized for her service and dedication to TCEQ for 20 years. She began her career in 2005. In April 2013, she began her role as executive assistant. She lent her skills to many endeavors. Especially noteworthy were her formidable contributions in launching the TCEQ mentoring program. That's a huge deal. Thank you so much. Now she retires as the very best of OAS. It's very sweet. People say that no one is irreplaceable, but whoever said that has never worked with Patty Love. It's so sweet.
Do we shake hands?
We do, and we're going to take a picture.
Okay.
Yeah. Thank you. Fun. Why don't we just switch off? That's okay.
Okay.
Just right here in the middle.
Okay.
Yeah, y'all stay up here so we can take. Okay. Kathy Humphrey. Is Kathy here? Nope. Well, Kathy, we don't have a proclamation for her. We just found out about her retirement very recently. One is coming soon, but she worked at the environmental laboratory sector for several years. She decided to go to law school, specifically to practice environmental law. She started with TNRCC in October of 1998. I was 1 year into college at that time, and was assigned to the water quality section. She developed a strong appreciation for the work of the water quality section, does and still finds water quality permitting fascinating. During her tenure at the agency, Kathy has also supported the Environmental Laboratory Accreditation Program, the OSFS program, the Edwards Aquifer program, and the MSW permitting program. Kathy will be forever grateful for all the many mentors and friends she has met during her tenure at TCEQ. Kathy, thank you. Yeah. John Minter, you here? Wow, man, okay. Yeah. No John Minter? No? All right. John is a staff attorney for OLS Air Section. He began working for TCEQ in 2002, and over the years has provided critical legal support for air quality division on air quality programs, including ozone, sulfur dioxide, and regional haze state implementation plan development, as well as advising the air permits division, Title V, and new source review team. He will be dearly missed. So thank you, John. Lewis? We've got someone. Come on up, Lewis. Lewis started with the agency in 1981, transferring from Texas A&M, whoop. He started as a municipal permit writer, drafting both state and federal discharge permits, and drafted over 1,000 permits in his career. He has been recognized and received awards from stakeholder groups, including multiple awards from the Environment Association of Texas and Water Reuse Association's 2022 National Advocacy Achievement Award, recognizing individuals for significant achievements in advancing policy, legislation, or regulations that facilitate greater adoption, implementation, or acceptance of recycled water. I don't know what to say. Your resume is incredible. You have done so much for this agency. You are going to be missed.
I think they're going to celebrate after I leave.
Oh, it is. I'm so happy for you. This for you. And I love the tie.
Thank you.
It's amazing. Good taste.
Yeah, I'll put this down here for you to see the stomach.
David Bauer here. Come on up, David. Aw. David is a registered professional geoscientist in the state of Texas. He earned his Bachelor of Science from the University of Texas in Austin. He began his professional career working for an oil and gas law firm in 1988. He started working with the Texas Water Commission, later to be TCEQ. He has held several positions within the agency in over his 37-year career with the agency, serving as a manager for over 25 of those years. He was the first area director of the Coastal and East Texas area, served as director of Field Ops Support Division, assistant director for the Field Ops Division, section manager and team leader of air, water, and waste enforcement programs. My goodness, you've got it all. You've done it all. Special assistant to the deputy director of enforcement, special assistant to the director of office and compliance and enforcement, and he started his journey with the agency as a project manager overseeing the assessment and remediation of leaking underground storage tanks, which are still a problem, across the state. David, come on up. Yes. It's in 37 minutes. Really emotional in a second. Kelly Cook. Come on up here, Kelly. Kelly is currently the Director of Critical Infrastructure Division in the Office of Compliance and Enforcement at TCEQ. TCEQ's critical infrastructure division consists of dam safety section and agency's homeland security program, the emergency management support team, the radioactive materials compliance and chemical reporting section, and the new emissions events reporting section. Kelly has 35 years of experience working at TCEQ, and he graduated from Texas A&M, so he's dear to my heart. He's also responsible for managing the agency's response to large disaster events such as Hurricane Ike and Harvey, the fertilizer plant explosion in West Texas, the Ebola outbreak, the ITC tank farm fire, and the Texas severe winter storms. And one of the kindest humans I've ever met, and just a gentleman and a scholar. And the state of Texas is so much better since you served it, and we're just really, really happy for you. Thank you. Thank you. Well, a quick note about Kelly. When I first got to the agency, I didn't have any TCEQ gear that fit. I am a small woman, and most of the shirts were down to my knees. And he has been on a quest to get me a properly sized pink TCEQ shirt since January. I think we've got it. So, and now he's retiring. So, they love him. Andy Gardner. Andy, are you here? Yep. Andy began his career with TCEQ in 2000 as a team leader in the Small Business and Local Government Assistance section. In 2008, he was promoted to the section manager and served in that role before becoming Deputy Director of the Program Support Environmental Assistance Division. He also served as Small Business Ombudsman from 2008 to 2022. He's the first to tell you that if he's accomplished anything in his near 25 years of service at the agency, it was directly related to his outstanding team members that surrounded him. Just incredibly sweet. Thank you, Andy. Julie Talley, here. Julie is recognized for an impressive 30-year career in public service in Texas with over 24 years at TCEQ. She began her career at DPS before joining TCEQ in 2000. Julie recently played an instrumental role in the successful implementation of CAPS HR and CAPS Recruit. That's probably why she's retiring, man. Showcasing her ability to navigate complex systems and drive change by emphasizing the development of processes that align with the strengths of her team members. Her legacy at TCEQ reflects professionalism, dedication, and a commitment to excellence. Thank you, Julie. This is small print. Last, we have Chris Mayben, and he is our Lubbock director, so I'm sure he is hopefully watching this from Lubbock. Chris is the regional director in our Lubbock office. He began his career with the agency in 1994 as a Mickey Leland intern. Oh, that's amazing. At the registration and reporting section in Austin before moving to the IHW permit section. After several years of learning and applying the industrial and hazardous waste rules, in 1998, Chris moved to the San Angelo regional office. In February 2003, he was part of the TCEQ response to the Space Shuttle Columbia incident. In 2005, he was embedded in the initial response to Hurricane Katrina in Louisiana, and then Hurricane Rita in Beaumont. Finally, in 2008, he was part of the TCEQ response to Hurricane Ike. In 2009, Chris was selected as the section manager in San Angelo and has been the director in Lubbock since 2021. He's a graduate of Tarleton State University with a degree in hydrology. When not working, he likes to spend time with his family, working on the ranch and tracing his roots. So thank you, Chris. You're in Lubbock, so thanks, Chris. And that is it for now.
Glad we have employees left.
Yes. Mary, first item, please.
Item number 1 is the consideration of the proposal for decision and proposed order concerning the executive director's denial of the application by Tony Mewis for an on-site sewage facility maintenance technician license. The parties have been notified that the order of presentation will be the applicant, the ED, and then OPIC, and that each party will have 5 minutes of oral argument time. The applicant may reserve a portion of his time for rebuttal as he bears the burden of proof. With that, I'll call for the applicant, but I don't see him on the registration list. Mr. Mewis, are you here?
Is he online? No? To ensure that Mr. Mewis has time to join us, we're going to move this item to the end of the agenda if my commissioners have no objection. Nope. All right, thank you. We're going to move to item 2.
Item number 2 is the consideration of an application by Uranium Energy Corp for a Class 3 injection well area permit renewal and amendment to underground injection control permit number UR3075. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Morning. Item 2 is the application by Uranium Energy Corp for a Class 3 injection well area permit renewal and amendment to authorize an in situ uranium mining. The Commission received numerous hearing requests on this matter. For these types of applications, the Commission considers a 2-step analysis. First, we determine whether hearing requesters qualify as affected persons, and if yes, we then consider whether those affected persons raised issues in their hearing requests that are referable to SOAH. Regarding effectiveness, the hearing requester must explain how they will be affected by the application in a way that is not common to the members of the general public. The hearing requester must also file timely comments in a hearing request that identify both their personal interest and the concerns with the application that are within the Commission's jurisdiction to address in the authorization. Governmental entities may establish effectiveness based on their statutory authority. Groups and associations have additional requirements, including, importantly for today's analysis, whether they have identified a member with standing. I believe Goliad County Groundwater Conservation District has established effectiveness. As a groundwater conservation district, its boundaries are co-intensive with the boundaries of Goliad County. Based on the statutory authority and the issues raised, I believe that the district has demonstrated a personal justiciable interest affected by the application and is affected. I also believe that 5 individual hearing requesters establish effectiveness: David Michelson and Linda Parker, Deborah Chapman, Gregory Chapman, and Jesse Ortega. These requesters own property that is located between 1/2 mile and about 1 mile from the permitted facility boundaries, and their expressed concerns qualify them as affected persons for this application. One individual, Kenneth Klinicka, attempted to clarify his effectiveness in a reply filing. Based on differing information, I believe it would be appropriate for us to refer Mr. Klinicka back to SOAH for an effectiveness determination at the preliminary hearing. I recommend that we deny all remaining hearing requests. I'll stop there and see where my colleagues landed on effectiveness. Bobby?
I saw it the same way. I'm comfortable with the effectiveness referral for Kenneth Klinicka as well, and agree on the same parties you named.
I'm in agreement.
Moving to the second part of our analysis on issues, I believe the identified affected persons raised relevant material issues within our jurisdiction to consider. I would recommend that we refer to SOAH issues concerning the adequate characterization of geology and hydrology, adequate information on pre-mining groundwater quality, the assessment of artificial penetrations in the area of review, protectiveness of groundwater and surface water quality, adequate monitoring, adequacy of amended control parameters, protectiveness of human health, wildlife, and livestock, and whether the operations authorized under the draft permit are in the public interest. I would recommend 180 hearing duration. Finally, I would recommend denying all requests for reconsideration. I don't believe they raised new relevant material information for the ED to further consider. Bobby?
I'm in agreement on every point you listed.
Also in agreement.
Do I have a motion?
I move that we grant the hearing requests of Goliad County Groundwater Conservation District, David Michelson and Linda Pinsker, Gregory Chapman, Deborah Chapman, and Jesse Ortega. I further move that we refer the hearing request of Kenneth Klinicka to SOAH for an effectiveness determination, that we deny all remaining hearing requests and all requests for reconsideration, and that we refer the application to SOAH for a contested case hearing on the following issues. Issue 1, whether the application provided adequate characterization of the geology and hydrology under applicable rules. Issue 2, whether the application provides adequate information on pre-mining groundwater quality under applicable rules. Issue 3, whether the application adequately assesses artificial penetrations in the area of review under applicable rules. Issue 4, whether operations under the draft permit are adequately protective of groundwater and surface water quality under applicable rules. Issue 5, whether the draft permit provides for adequate monitoring under applicable rules. Issue 6, whether the draft permit's amended control parameters are adequately protective under applicable rules. Issue 7, whether operations under the draft permit are adequately protective of human health, wildlife, and livestock. And finally, Issue 8, whether the operations authorized under the draft permit are in the public interest under Texas Water Code Section 27.051A and the applicable rules. And I finally move that we set a hearing duration of 180 days from the date of the preliminary hearing until the proposal for decision is issued.
Second.
All those in favor say aye.
Aye.
The motion passes. Thank you. All right, we will move to item number 3. We'll give everyone a second to shuffle.
Item number 3 is the consideration of an application by Beaumont New Ammonia LLC, formerly known as OCI Clean Ammonia LLC, for an amendment of air quality permit number 169687. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Good morning. Before us for consideration is an application by Beaumont New Ammonia for an amendment to its air quality permit to authorize a second ammonia production train. We received several hearing requests in this matter, raising concerns relating to air quality impacts, best available control technology, compliance history, environmental justice, and permit requirements. I note that the concerns expressed in the requests raise interest common to all residents in the area, rather than specific impacts to the requesters. Based on these general concerns, I don't believe that any of the requesters demonstrated a personal justiciable interest in this application. For this and other reasons, I would deny all hearing requests in this matter, issue the permit amendment, and adopt the executive director's response to comment. Bobby?
I'm in agreement.
Also in agreement.
Do I have a motion?
I move that we deny all hearing requests, issue amended air quality permit number 169687 to Beaumont New Ammonia LLC as recommended by the executive director, and that we adopt the executive director's response to comments.
I second the motion.
All those in favor say aye.
Aye.
Aye. The motion passes. Thank you.
Item number 4 is the consideration for approval of the TCEQ Chief Auditor's Office fiscal year 2026 audit plan, and the Chief Auditor is here to present this item.
Mike, you want to go ahead?
Thank you. Good morning, Chairwoman Pop, Commissioner Janeka, Commissioner Gonzalez, General Counsel, Public Interest Counsel. For the record, my name is Mike Hardison, and I'm the Chief Auditor of the TCEQ. I'm joined today by my Deputy Chief Auditor, Gail Zambi. We're here today to present and seek approval of our annual risk assessment and fiscal year 2026 audit plan that was prepared by my office. Texas Government Code 2102 requires that the chief auditor of an agency prepare a risk-based audit plan on an annual basis, and that plan has to be approved by the commission. In order to address and identify the risks facing the agency, my staff and I conducted interviews with individuals charged with governance and other selected TCEQ management and staff. We also reviewed prior internal and external audit reports related to agency processes. We performed financial analyses related to TCEQ funding and expenditures. We reviewed turnover and staffing by office, and then used those attributes to risk rank concerns identified by our office in order to best allocate our existing resources and address the highest risks identified. The report before you describes our methods as well as our planned efforts to address risks identified during our process. I would like to thank each of you, as well as the executive director's staff and the executive director, for y'all's participation in this project. At this time, I'd like to request your approval of this report, the fiscal year 2026 audit plan, and I welcome any questions you may have.
Thank you. Garrett?
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports approval of the Chief Auditor's Office fiscal year 2026 audit plan.
No one is registered for this number. We will talk about the audit plan and then talk about the auditor. I've reviewed the audit plan. I think having a super sleuth as a chief auditor is incredibly important. We strive at TCEQ for continuous improvement. Audits do that. They show us what we need to improve and how we need to improve, and we implement, and they are incredibly beneficial to the agency. But that takes someone very, very special and detail-oriented and kind of a bulldog to figure that out, and that is Mike. Mike is retiring, and it is a big deal. He's retiring after 17 years of state service. 15 have been with us in the auditor's office, and in the last 7, he's served as the chief auditor. Those have been some interesting and challenging years. He led his office through COVID to CAPS. Why is COVID considered with CAPS? This is under Mike's leadership, the auditor's office has conducted over 100 audits and reports which is a stunning number of audits when you take into account that there are other sized agencies that produce maybe 4, 5 reports in a year. More importantly, those audits are conducted professionally, thoroughly, and in the spirit of identifying potential issues before they become an outsized problem. That's really important to us. I can't express how thankful we are for your leadership, Mike. I'd like to present you a flag that was flown over the Texas Capitol and express everyone's heartfelt gratitude for everything you've done in the service of this agency and for the people of Texas. Colleagues, do you have anything to add? And we'll go take a picture.
I can't help but read over and reflect on the different carryover projects, the planned engagements and projects that the Chief Auditor's Office has lined up and you're reporting to our agency on. One piece of feedback that I've heard consistently from other people that's really lined up with my own experience is how much your engagement really does improve our agency and it betters our process. Your deliberate thought in constructing that audit plan and choosing which projects to engage with often set us up in the best position possible to take and act on the feedback and the course corrections that we become aware of in the course of your staff's work with our other agency staff, and that actively improves our agency as we are going, and where we have so many pressures and so many different objectives our agency responds to. I think that's a really useful tool in our toolbox to be continually improving in a meaningful way, and I expect that our agency will have some challenges as you move on to other adventures, which I'm very, very happy to, spoiler alert, we'll be discussing and commemorating that occasion. But as I've started to reckon with, oh gosh, what will that change in your position in our agency bring for us, and what will that mean? One thing that's become just overwhelmingly apparent is what a true value you do bring to our agency and our state. And so thank you very much. Thank you to your team. I think it's a really great approach to do business with the audit minds that you bring in our agency and our Chief Auditor's Office that sets us apart from other agencies. So I hope the staff realize the value there as well, and they continue to improve the state. And you can watch and call us up and tell us how to continue to do it better from your new vantage point, as you can feel freer to speak truth to a role where you're doing that now in a very important role for our agency.
I've very much enjoyed working with you, and I think, when I first joined the commission, after I met with you, I had a definite level of comfort about the agency, knowing that you were there to make sure that we were doing things correctly or catching us when we weren't. And I want you to have the best retirement ever, although I'm sad that we're going to lose you. And I always think of times like this when you're uncomfortable or when there's change, and believe me, I'm very uncomfortable with this. It's an opportunity for growth, and so I think that as an agency, we'll have an opportunity for growth. Won't be easy, but we'll be up to the challenge. Thank you, sir.
One thing to know about Mike is he rode his motorcycle from Texas to Canada in 18 hours? No, 24 hours?
No, ma'am. I started in Round Rock, Texas, and ended up in Regina, Canada, 34 and a half hours.
34 and a half hours, okay. It's a rocket, sorry. Mike, you work so well with everyone in this agency. Implementing audits, it's not easy. You have to get in the weeds. You have to get in people's business. Employees have to stop what they're doing to talk to you, to be interviewed. It's not always fun, but you run such a great audit shop. Everyone is so congenial and so ready to just make TCEQ a better place. It works really well. So we are happy for you. We are sad for you. I hope to see you back in 6 months, along with everyone else who's retired. But very, very happy for you. Let's take this vote and then take a picture. I move that we approve the TCEQ Chief Auditor's Office Fiscal Year 2026 Audit Plan as recommended by the Chief Auditor.
I second.
All those in favor say aye.
Aye.
The motion passes. Thank you, Mike. This is a bittersweet meeting, isn't it? Let's go to the next item, Mary.
Item number 5 is consideration for approval of the agency's FY 2026 operating budget. The executive director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Janae Burrs, the Deputy Director of the Budget and Planning Division. With me is Elizabeth Cifuentes-Koch, the Chief Budget and Efficiency Officer in the Executive Office. I'm here to present the Executive Director's recommended fiscal year 2026 operating budget. This information was compiled in accordance with the General Appropriations Act, Senate Bill 1, and the Supplemental Appropriations Act, House Bill 500. Turning to page 1 of the fiscal year 2026 operating budget. Page 1, the total budget for fiscal year 2026 is $687 million, compared to fiscal year 2025 budget of $556 million. This is an increase of $131 million, or 24%. The increase is attributed to the exceptional item request, the rider funding for Senate Bill 7, which was the oversight and financing of water infrastructure, and Senate Bill 1145, the transfer of land application permits of produced water. The FTE cap has increased by 172.5 and includes the positions requested in the exceptional items and authorized in the 2 pieces of legislation. The budget does not show a significant change in federal funding. The difference noted on page 1 is due to the grants being loaded in fiscal year 25 with the expectation of being carried forward to 2026, the next year. Turn to page 2. It provides an illustration of the method of finance for FY 2026, which reflects the fact that 82% of the agency's budget comes from funds paid in fees. The appropriated fee funds make up 54% of the budget, and the TERP fee funds are 27% of the budget. On page 3, it shows the allocation of FTEs by office. As stated earlier, the number of FTEs has increased for this new year by 172.5. Moving to page 4, it provides a comparison of the budget by office. The new funding shown in the last row under 89th legislative session, or the new funding that we received during the legislative session is shown on the very last row. The large increase in the Office of Air is because of the revenue projections for the TERP Trust Fund. And on page 5, it provides a comparison of the budget by category. By budget category, the largest percentage change is related to other operating, which is increased by $46.6 million, or 90%, which is mostly in professional temporary services and other operating. You may recall that several of our exceptional items funded by the legislature included this funding in these budget categories. Page 6 provides a list of programs supporting remediation, reimbursement, and grant contracts. Page 7 and 8 provide details of the capital budget. And the final page, page 9, provides a summary of the estimated budget for the TERP programs. This table is based on the current revenue and program estimates. And this concludes the presentation of the fiscal year 26 operating budget, and we're very happy to take any questions you may have.
Thank you, Janae. Excellent presentation. Mary, do we have anyone signed on this item?
No, we don't have anyone signed in here.
Garrett?
OPIC supports approval of the fiscal year 2026 operating budget.
I'd like to thank the ED and especially those in OAS who have worked on putting this operating budget together. It was very exciting to see all of that hard work this session with those exceptional items in our actual budget. TCEQ had an extraordinary session thanks to all the employees at the agency. I'm ready to move forward with approving it. Colleagues?
Likewise.
Do I have a motion?
I move that we approve the Commission's fiscal year 2026 operating budget as recommended by the Executive Director.
Second?
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you. Thank you, Janae. Thank you, Elizabeth. All right, we will go to the enforcement docket.
So the enforcement docket are items 6 through 19, and the executive director's staff is here to present these matters.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today are Amy Sedemeyer, also of the Enforcement Division, and Gitanjali Yadav of the Litigation Division representing the Executive Director. Pending before you are items 6 through 19. The total assessed administrative penalties are $376,928, with $64,927 deferred, and $312,001 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. Mary, do we have anyone signed up on these items?
On items 6, 7, 8, and 12, we have individuals who are signed in and indicated that they're available for questions, but they're not asking to speak, and their presence will be noted for the record.
Okay. Garrett?
OPIC has reviewed each of these enforcement items, and we support adoption of all the orders presented by ED staff.
Thank you, OPIC. I've reviewed these items. Thanks, staff, for the work that went into bringing these before us today. Do have one quick question. I'm wondering if you can tell me what the past fine amounts are on items 13 and 15.
Good morning again, Melissa Cordell, Enforcement Division. For item 13, the regulated assessment fees are the reason why that says past due penalties is yes. And in this particular case, the regulated assessment fees are dependent on the entity reporting their annual revenue. In this case, they did not do that, so we were not able to have an actual number to populate in that spot. For item 15, past due penalty amounts or past due fees, which could also be in this grouping for the Enforcement Division, it can be fluid. We do review these. In this particular case, though, there is not a past due penalty or fee.
Okay. Thank you. Thank you. Colleagues, any questions?
Now you piqued my curiosity. Sorry, you cracked open the curtain, and I'm curious about how things operate. What's the average fee that revenue for an entity subject to these types of facilities, or back of the envelope, a typical fee or range of fee?
I would like to invite Michelle Risco, who is my...
I love it when you all have answers
Call a friend.
in the wings.
Good morning. For the record, my name is Michelle Risco. I'm the Deputy Director of the Water Supply Division. We administer this fee. So the regulatory assessment fee is actually going to be a percent of the receipts of a water utility. So it's going to depend on the type. If they're an investor-owned utility, it's 1%. If they are a water district, a water supply corporation, or an affected county, that's going to be 1/2 of 1%. I'm sorry, affected counties are also 1%. So it depends on if they're a very small utility and they have, $1,000 in revenue, we're looking at a $10 fee. Whereas if we're looking at a Class A utility with millions of dollars, we're looking at 1% of that.
I appreciate that answer, and I think that gives a good background comparison of the $2,350 assessment before us on this matter. As I'm reminded, we are strictly limited to speaking on, so thank you. Appreciate it. No questions.
Katerina? I'm ready to adopt these orders. Colleagues?
Likewise.
All right, I move that we adopt items 6 through 19 as recommended today by the executive director.
A second.
All those in favor say aye.
Aye.
Motion passes. Thank you. Let's go to the monthly enforcement report.
Item 20 is the monthly enforcement report, and the executive director's staff are here to present.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Amy Sedemeyer of the Enforcement Division, and with me are Melissa Cordell of the Enforcement Division and Gitanjali Yadav of the Litigation Division. We're here to present the monthly enforcement report for fiscal year 2025 through June. There were 904 effective orders issued, and of those, 83 contained supplemental environmental projects. These orders assessed a total of $11,424,039 with a payable amount of $7,232,360. $2,536,529 are to be paid towards supplemental environmental projects. 16,316 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 1,498 enforcement action referrals have been received. There are 3,186 pending administrative orders, with 1,391 cases that are on the backlog. 132 cases are pending at the Attorney General's office for representation in district court, and 9 judgments have been issued. 1,495 cases are being tracked for compliance. We're available to answer any questions you have.
Thank you.
Do you want to ask, looking at the different charts which you provide on the report, and they're always helpful, thank you. The one reportable that looks like the line isn't in the direction that I would love to see relative to the other years is on the number of supplemental environmental projects. I'm curious, have you fully realized some of the analysis that we've undertaken or consideration we gave to our process to try to smooth the glide path, make it easier to simply check yes in a step in your enforcement process to participate in the SET program rather than needing to reapply and actively participate elsewhere? Should we consider that those efforts have been reflected in these figures we see before us in the report yet, and if not, when?
Gitanjali Yadav with the Litigation Division. So we are still looking into whether we can get a SET checkbox incorporated, and that we're actively developing that. We have not come up with something. I'm hoping, that we get that. It's not for lack of interest in the SET program. We do have 156 SEP applications that we have reviewed and approved. They just need to be incorporated into the order. So they're coming.
Appreciate that response. That's great to hear. And eager to discuss any constraints that we identify on the SEP checkbox front. I'd love to flag that for state leadership to consider or be aware of. Thank you.
Any questions? Garrett?
OPIC has no comment on the report except to say that we appreciate receiving it. Thanks.
Thank you, Garrett.
And no one has signed in on this item.
Thank you, Mary. Glad to see that we're chipping away at that backlog. I'm hoping that 172.5 new FTEs will help with that as well. I appreciate all the work that OCE is doing to move forward on this enforcement docket. Colleagues, ready to move forward on this? We don't have any action, but just anything to add? Anything to add? Nope. All right, that's it. Thank you.
That brings us to items 21 and 22, which are the consideration of 2 petitions for rulemaking filed by Kyle Cromer, the Vice President of Tank Builders Incorporated, to amend 30 Texas Administrative Code Section 290.43C6 and C8. Mr. Cromer, the Vice President of Tank Builders, represents the petitioner and may present the matter, followed by other interested persons, the ED, and then OPIC. Speakers will be limited to 5 minutes each for their presentation, and the petitioner may reserve time for closing remarks. The petitioner has not registered, is not signed in unless Mr. Kramer, you've slipped into the building here, into the meeting room. We have no interested persons signed in, so I think we can move to the ED.
Good morning. Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Michelle Risco with the Water Supply Division. With me today is Ruth Takita from the Environmental Law Division. The Executive Director does not support the recommended rulemaking for either of the two petitions filed by the Tank Builders Incorporated. In the first petition, the petitioner requests the Commission amend 30 Texas Administrative Code 290.43C8 by adding requirements that include tank coatings to be certified to the National Sanitation Foundation International, American National Standards Institute, Canadian Standards Association, NSF-ANSI, and CAN for short, Standard 600, in addition to the current requirement for certification with NSF and ANSI Standard 61. As the proposed rule changes would also include require all tanks now and in the future to be made of NSF Standard 61 concrete or be coated either in a coating, if this is not required or recommended. The proposed amendment would finally prohibit any exceptions to these requirements based on tank material. The Executive Director believes that the existing rule is sufficiently protective of public drinking water because it already requires tank coatings to be certified to NSF, ANSI, and CAN Standard 61. In addition, Standard 600 is a reference standard, which means that no products can be certified to Standard 600. The proposed amendments would impose a requirement beyond that required by national standards, and the Executive Director believes that an amended rule would not result in an increase in public health protection. In the second petition, the petitioner requests that the Commission amend 30 Texas Administrative Code 290.43C6. The Executive Director disagrees that the proposed amendment would clarify the current requirement for water tanks to be tight against leakage. The proposed amendment would prohibit measurable calculated leakage during hydrostatic testing for all tanks, which contradicts national standards and does not consider material properties. The existing rule clearly states that potable water storage tanks shall be thoroughly tight against leakage. Leakage is adequately addressed in the rule because 290.43C requires tanks to be designed, fabricated, erected, tested, and disinfected in accordance with current AWA standards. AWA standards are national consensus standards and do not allow leaking for any tank types. Thank you, and we're available for any questions you may have.
Thank you. Garrett?
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez. I'm Senior Attorney for the Office of Public Interest Counsel for the record. We've reviewed these rule petitions and recommend that they be denied because they are unnecessary, do not provide additional protection to the public, and may result in unenforceable provisions. Specifically as to item 21, the American Water Works Association Standard D-110 already requires that tanks be leak-proof and that all leaks identified during testing be located and permanently sealed. A small amount of net liquid loss, however, is a function of water absorption in some media and cannot be prevented. As to item 22, NSF 600 is a reference standard and products cannot be certified to that standard. Further, there are some tanks that do not require coating to protect the public health, and therefore requiring the use of a chemical coating for these types of tanks is both unnecessary and may have potential unwanted impacts on public water systems. For these reasons, we recommend that the rule petitions be denied, and we're available for any questions.
Thank you, Eli. I've reviewed the petitions and the ED's response. These petitions are relatively limited in scope, and I believe that the ED has already fully considered the petitions, which appear to be based on a misunderstanding of testing methods and material needs of a wide array of tanks that can safely be used to store drinking water. I believe that the ED has offered understandable reasons for not further exploring potential amendments to the tank rules. I would deny both the petitions. Regarding the petition to amend Section 290.43C6, I believe that the ED has explained how the current rule ensures public health and safety and that no national and public health or safety organization standards would support the petition. For the petition to amend Section 290.43C8, the ED has shown that the current rule protects public health and safety and that the amendment could result in unintended consequences for water systems that would unnecessarily increase costs. I'm prepared to deny the rulemaking petitions today. Colleagues,
I'm in agreement.
Same.
do I have a motion?
I move that we deny the petition for rulemaking filed by Tank Builders Incorporated to amend 30 Texas Administrative Code, Section 290.43C6, because the current rule ensures protection of public health and safety and no national or public health or safety organization standard supports the proposed amendment, and that we deny the petition for rulemaking filed by Tank Builders, Inc. to amend 30 Texas Administrative Code, Section 290.43C8, because the current rule ensures protection of public health and safety, and the proposed amendment would not appreciably protect public health and could result in unintended consequences for public water systems, such as requiring coatings when unnecessary and increasing costs with no public health or environmental benefit.
A second.
All those in favor say aye.
Aye.
The motion passes. Thank you. Let's move on to item 23, please.
Item number 23 is the consideration of the publication of and hearing on proposed amendments and updates to 30 TAC Chapter 17, Tax Relief for Property Used for Environmental Protection, and 30 TAC Chapter 18, Voter Approval Tax Relief for Pollution Control Requirements. The Executive Director's staff is here to present this item.
Morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Elizabeth Sartain with the Air Quality Division. With me is Diane Goss with the Environmental Law Division. For your consideration today is item 23, the Executive Director's proposed revisions to 30 Texas Administrative Code, Chapter 17, Tax Relief for Property Used for Environmental Protection, and Chapter 18, Voter Approval Tax Relief for Pollution Control Requirements. The proposed rulemaking would implement provisions from Senate Bill 2 from the 88th regular legislative session, add certain components of amine treating systems to the Tier 1 tables in both chapters, and fulfill the Commission's statutory and regulatory requirements to review and update as necessary expedited review lists and Tier 1 tables. The proposed rulemaking would also modernize various aspects of the program, clarify that the Executive Director specifies the form of application submittal, move the expedited review list in Chapter 17 to a new section, and remove existing requirements that the Commission review and update the Tier 1 tables every 3 years. Staff respectfully recommends approval to propose publication of and hold a hearing on the proposed Chapter 17 tax relief for property used for environmental protection and Chapter 18 voter approval tax relief for pollution control requirements. We are available to answer any questions. Thank you.
Thank you very much. Has anyone signed in on this item?
No one is signed in.
OPIC?
Good morning. Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorneys, and staff. For the record, I'm Jessica Anderson on behalf of the Office of Public Interest Counsel. OPIC has reviewed this proposal for rulemaking and respectfully recommends publication. The purpose of this rulemaking is to amend the Tier 1 tables in 30 TAC Chapters 17 and 18 and to implement Section 44 of SB 2 of the 86th Texas Legislature regular session, which requires rulemaking to correct the title of 30 TAC Chapter 18 to voter approval tax rate relief for pollution control requirements. OPIC notes that this proposed rulemaking could impact members of the public by affecting appraisal districts that grant and determine the value of tax exemptions. OPIC further notes that while the Commission did not hold any stakeholder meetings related to this rulemaking, if the proposed rulemaking is approved by the Commission for public comment and public hearing, then a formal public comment period would be opened and a public hearing would be offered. Additionally, the recommendations of the Tax Relief for Pollution Control Property Advisory Committee were discussed at 5 meetings in 2021 and 2022. Thank you, and I'm available for any questions.
Thank you very much. I've reviewed the back of material on this rulemaking proposal and want to thank staff and members of the Tax Relief for Pollution Control Property Advisory Committee for their work on this rule project. These updates will correct a heading from a previous legislative rulemaking, add property that the advisory committee has identified as candidates for Tier 1 listing, free up the program to review Tier 1 properties more frequently, and will update the program so that all application appeals are electronically submitted. I'm ready to see what the public thinks, so I support moving forward with the publication. Bobby?
Likewise, I think the public participation on this program area that our agency engages with the public on, we've seen meaningful feedback in the past few occasions, so I remain confident that shifting from a routine scheduled requirement and rules to considering that changing the table as changes are needed will be a perfectly acceptable frequency for agency to maintain.
Katarina?
Do we know why that 3-year period was included to begin with?
Commissioners, I'm Diane Goss, Environmental Law Division. The legislative history on this and in the form of the preambles are silent on that, and we do not have institutional knowledge here with us at the agency at this time who has the actual knowledge of why it was done.
I can't help but imagine some retired attorney out in our state somewhere who's watching this meeting happen right now go, I know that answer.
I guess I would just say that as we move forward with rulemakings in the future, you know, it I think helpful for someone to at least know that relevant info if it needs to be in the preamble, or if we're putting things in rules. It's my understanding this wasn't statutorily required, so if we're putting things in rules, so please be mindful if it's not statutorily required that maybe it doesn't need to be there.
Okay. Do I have a motion?
I move that we approve the publication of and hearing on the proposed, making sure I'm doing it wrong, the proposed amendments and updates to the 30 Texas Administrative Code Chapters 17 and 18 as recommended by the Executive Director.
Second.
All those in favor say aye.
Aye.
Motion passes. Thank you. I believe we're going to go back to item number 1.
Number one is consideration of the proposal for decision and proposed order concerning the ED's denial of the application by Tony Mewis for an on-site sewage facility maintenance technician license. I won't go through the oral argument order again. I will note that Mr. Mewis has not arrived and he's not currently on the webinar, so I recommend we begin with the ED.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. My name is Maricela Zertucci, and with me is Haya Zeman, P.E., Deputy Director of the Occupational Licensing and Registration Division. We represent the Executive Director in this matter. The ED agrees with the Administrative Law Judge's proposal for decision and proposed order as amended on May 7, 2025, and recommends that the Commission adopt them. We are available for any questions.
I have a question. Go. Looking at the criminal history, and it looked to me like the most recent one was 2017. For this type of license or registration, what would that kind of time period be under the rules for when he would be eligible? Like, basically, how far removed do you have to be from your past criminal activity?
So, for the record, I'm Haya Zeman, Deputy Director for the Occupational Licensing and Registration Division. There is no concrete timeline. There are some crimes that can be considered for a long time, and some others that we consider the clean record and how much time has elapsed. It has to do with other factors that are in the statute that we need to consider, like the extent and nature, repeated offenses, the age of the applicant at the time, and the risk of the license. And the access that the public is going to have, that the applicant is going to have to unattended property or persons, and the risk of potential harm. We don't have a specific timeline, but we definitely do consider the amount of time that has elapsed since somebody has been released from probation. And that they have had a clean record since then. And then we also consider some other mitigating circumstances, like letters of recommendation or any other rehabilitative efforts that the individual has undergone, whether in prison or out of prison. So there are many, many factors that get into consideration in those decisions.
Okay, thank you.
Yes, can you, how many felonies does Mr. Mewis have? I believe 3. And several misdemeanors spanning from 18 to age 47, correct? So it's quite a lengthy amount of time and quite a various record.
Yeah, that is correct. So that's the extent and nature that gets into consideration, and then the time that the individual was out of prison with a clean record versus the time that he had spent in prison.
Thank you. OPIC?
Good morning again, Chairwoman, Commissioners, General Counsel, and Executive Director. My name is Eli Martinez with the Office of Public Interest Counsel. For the record, I've reviewed the closing arguments and post-hearing briefing for this matter, and we support adopting the Administrative Law Judge's amended proposal for decision, recommending the denial of Tony Mewis's application for an on-site sewage facility maintenance technician's license. Our position is based on the evidence, applicable law, and the need to safeguard the public from risks associated with granting a high-risk license to an applicant with a significant criminal history. First, Mr. Mewis's criminal history directly relates to the duties of the technician, a factor that the Commission must consider under Texas Occupations Code, Section 53022. Mr. Mewis's convictions include state jail felonies for forgery in 2005 and 6, second-degree felony for burglary in 2012, Class B misdemeanor for failure to stop and give information in 2015, third-degree felony for tampering with evidence in 2016, and 2 Class B misdemeanors for theft in 2018. He also had earlier convictions in 1990 for forgery and burglary. These crimes, especially burglary, forgery, and theft, involve dishonesty and unauthorized property access, which align closely with the technician's role. This job requires entering private homes and handling financial information for payments, creating opportunities for similar offenses. TCEQ guidelines classify the technician license as high risk due to its access to residences and direct public interaction, which could enable reoffending. Second, the fitness factors in Texas Occupations Code, Section 53023, weigh against approving the application. Mr. Mewis's criminal activity spans from age 19 to 47, showing a prolonged pattern of serious offenses, including felonies. His most recent convictions were in 2018, with probation ending in December 2018. He applied for the license in April of 2023, only about 5 years later, too short a time in our estimation to demonstrate sustained rehabilitation. While he testified to attending church, participating in Alcoholics Anonymous, and leading a support group, which are all very encouraging and laudable actions, for now, these efforts are outweighed by the recency and severity of his crimes. Importantly, a letter of recommendation supporting his application was later rescinded, and the author cited Mr. Mewis's multiple unethical practices. This retraction significantly weakens his claims of rehabilitation. Granting the license could expose homeowners to potential harm, risking public safety and damaging TCEQ's credibility if an incident occurs during his work. Third, the burden of proof supports denial. The Executive Director met the burden to prove the basis for denial under Rule 80.17. Mr. Mewis, as applicant, failed to prove by a preponderance of the evidence that he is presently
fit to hold the license. From a public interest perspective, allowing an applicant with a recent and extensive criminal history involving dishonesty and property crimes to hold an on-site sewage facility maintenance technician's license could jeopardize environmental safety and public trust in TCEQ's oversight. While we acknowledge Mr. Mewis's rehabilitation efforts, the recency of his convictions and the rescinded letter indicate that more time and stronger evidence of change are needed. OPIC supports his right to reapply in the future with a more robust record of rehabilitation. We therefore recommend, with all due regard, that the Commission adopt the ALJ's findings of fact, conclusions of law, and order, denying Mr. Mewis's application for an on-site sewage facility maintenance technician. We're available for any questions.
Thank you, Eli. I have questions. You mentioned, sort of the same question, the recency. So in your opinion, what would that time period look like?
I have a similar answer, honestly. It's not necessarily the number of years. I think you have to look at kind of the duration of the crimes and the severity of the crimes and how they would apply to the license that he's seeking, what types of access that he would have, and what the evidence of the rehabilitation shows comprehensively. I'll say that the rescinded letter of recommendation weighed heavily on my conscience. That's even more recent than some of the crimes that he committed. The fact that the person that had recommended him now states that he had multiple ethical offenses recently weighed heavily on my mind. But I think that you have to look at the extent, the nature, the time frame, whether or not the actions were repeated, whether or not the crimes were of moral turpitude, and it all puts together kind of a picture whether or not that you feel is appropriate at this time. And when we applied that standard, this is how we came out.
What is it exactly that this person, this license does?
Well, it's an on-site sewage application. I know that it has. I don't know exactly technically what that job entails, other than that it gives access to homes, and that was the most important part. There's components of that sewage facility that gives access to people's homes, and so to be honest, my Josiah Mercer was the original attorney on this case, and he heard all of the evidence in court. I reviewed all of the evidence and the briefings, so I wasn't party to kind of the description of the nitty-gritty of the technical details of this job, but I do understand that it gives access to the home and payment systems, and that's what I needed to be able to apply the standard.
I'm going to ask the same question to the ED staff. What exactly do they do? Because I keep hearing access to homes, but my understanding is this is more of a outside sort of thing.
And I'd like to remind the ED too that we can't have additional testimony for the commission to consider, so it would be better if I just want to make sure that all of the answers are restricted to the evidence that is in the record or argument by an attorney. Thanks.
Should I answer the question about the duties? Or the maintenance technician?
Is that in the record?
I believe it's in the record, yes.
I mean, we're having conversations with regard to it being related directly to the duty, so I'm asking what the duties are.
If you'd like to continue this for a moment, we can. I can give you legal advice recess for a moment. I can give you legal advice.
I'm just asking what the duties are.
Yes, and they need to be in the record for you to consider them, or if they need to be a law or argument by an attorney. I would like for the commission's decision, if appealed, to be within the bounds of the strictures of the Administrative Procedures Act, so that the decision is protected.
May I take a quick break? I wanted to ask OGC a question on this.
Let's take a 5-minute recess, please. This board meeting is back in session. The time is 11:07. Believe we just ended with OPIC. And do you have any
Yes.
further questions?
So upon advice from counsel, I'm going to direct my question to the attorney rather than the person who provided witness testimony. And I'm going to ask, it is my understanding that in the record there is some testimony on what exactly this sort of licensee does. And could you tell me where that is and what that is?
So in the record, we aren't aware that we talked about the, and I apologize, I was not the attorney that tried this, so, but there is testimony about the commission guidelines that assess the risk level of this kind of technician as high, and that this type of license would give him access to clients' homes and financial information for payment. And so that's what we were basing the decision to deny the license on.
I get that. I've heard that now a couple times, but I still haven't. I'm still not clear how exactly that transpires. But I'll just move on from there. Bobby, did you have a question? You seem like you. Okay. I'll just save my remarks for when y'all are done.
All right. Well, I take our role and responsibility when reviewing whether to deny a license application very seriously. I do believe in rehabilitation. I do believe in second chances. I'd like to commend Mr. Mewis's continued efforts to improve his circumstances and rebuild his life after several criminal convictions, particularly his efforts to remain sober over the past 10 years. He attends AA and church regularly. Sobriety is a really beautiful thing and can be life-changing. But I also take very seriously our role to ensure that the public is protected when issuing these licenses. And in balance, I can't recommend a license in this case given the nature and the pattern of continued crimes committed from age 19 to 47. I think in the record, there was ED8. It wasn't admitted until after the conclusion of the hearing, but in ED8, Mr. Mewis's former employer states that Mr. Mewis has shown multiple unethical practices, and I would like to remove my letter of recommendation that I submitted to your office on his behalf. That stuck out to me, honestly, because the majority of the offenses did end back pre-COVID, but that letter is recent. That was a recent revocation of recommendation. That led me to think maybe the rehabilitation is not complete yet, and maybe Mr. Mewis needs more time to become a better citizen. The Texas Occupations Code provides several statutory factors to consider when determining past criminal convictions relating to the duties and responsibilities to a license, including the nature and seriousness of the crime and the extent to which the license may provide an opportunity to engage in criminal activity of the same type. In this case, I found that the past record supports the ALJ's findings that Mr. Mewis' past criminal convictions, particularly his convictions related to forgery, burglary, and theft, directly relate to the duties and responsibilities of an OSSF maintenance technician license. Given his history and pattern of criminal convictions, I believe that the record supports the ALJ's and ED's recommendation to deny the license application at this time. I'll stop and talk to my colleagues.
I don't want to belabor the particulars. In this case, I'm satisfied and in agreement with the ED's position and with the findings from the ALJ. Like my colleagues, I think I recall some matters that have come before us on other similar authorizations. Not this exact one, but where our agency has similar concerns about the access that's afforded by those permit holders or license holders. And I recall where SOAH found differently and recommended that we grant that case. So I take some comfort in the assurances of the case-by-case review that OPIC and our ED staff have both articulated is necessary for approaching all these decisions. I just want to express generally, I think that our agency has room to do better. We don't have all of the expertise and fluency to engage with these types of matters with the full depth and rigor that we do with geotechnical issues, other scientific matters that we deal with. This is entirely outside of our wheelhouse, but it's an area we have undertaken to seriously contend with, and I encourage the Mr. Mewis in this case and others who come before our agency and want to submit and request consideration for authorization for different programs that our agency engages with. I think that you can present a good argument to us and to an administrative law judge where more often than not that may be the pathway that will get done because it's so out of our agency's wheelhouse. I don't expect our agency to ever be seeing so many Texans wanting to, because this is a relatively small number of programs, so many Texans wanting to receive this type of consideration that we're going to really iron out and provide guidance and provide, here's this type of year, this type of a range. But I do take hope in the depth of rigor in the process, presenting at times decision points that look different for us, and I'm really encouraged by the question and interest from both of y'all. I really appreciate both of you taking the apparent time and consideration that you have both given to this matter, because I believe as well that rehabilitation is important, and I think that that's part of our charge under the law for this program. I turn to the Occupations Code where there's the legislative intent of the chapter that we are implementing under this program and under our rules. It states that the intent of the legislature is to enhance opportunities for a person to obtain gainful employment after the person has been convicted of an offense and discharged the sentence for the offense. And the state law instructs those following it to liberally construe that chapter to carry out the intent of the legislature. And I think that the chapter goes on further to obligate us to consider evidence and consider arguments that are presented from people seeking to get authorized. Doesn't give us any direction beyond that. And I think that that's an appropriate reflection in this matter that's come before us. I'm ready to move forward as the ALJ will send it back to us. Thanks.
I also, despite my questions, am ready to move forward. I appreciate both of my colleagues' comments on this. I also am a firm believer in rehabilitation. I don't think that our charge is to deny a person a livelihood for the rest of their life. So I think that we have to carefully consider that. And I also believe that the legislature has past several sessions, they've made a real move and a real effort in occupational licensing reform to make it easier for people to attain a license and a livelihood. And so I take that to heart, that's the charge. I do, I also take very seriously our, we have to protect the public. It was also a concern to me that the letter was withdrawn. I would have liked for Mr. Mewis to be here today or to phone in so we could have heard from him, but we didn't confine to the record. And so on the record, I think I'm going to agree with my colleagues on denying it. I will just sort of generally, as a policy matter for the agency, I think it's important that we take a hard look at these and that we have a real understanding of what that licensee is doing and what the connection is to their past record. Because I don't feel like we had that completely here, and I'd really like to see that moving forward and to really consider these things. Thank you.
Thank you. With that, I would support the ALJ's proposed order with two changes. First, I'd correct the heading and first paragraph of the ALJ's proposed order to correctly identify Mr. Mewis applied for an on-site sewage maintenance technician license. Second, I would amend finding of fact number 4 to reflect that the applicant, as the moving party, bears the burden of proof in this matter, as this is consistent with our procedural rules in 30 Texas Administrative Code Chapter 80. finally, I think most importantly today, I'd like to state that our ruling, whatever our ruling may be, does not prevent Mr. Mewis from applying for another lower risk TCEQ license. I have a regulatory guidance, and I've asked my senior advisor to pull the lower risk license just to see what that means and what this might do for Mr. Mewis, and if this would be something that he is interested in. But so be it. I have a motion that I can make if you're all ready. All right. I move we adopt the administrative law judge's proposed order as revised by the ALJ's letter regarding exceptions dated June 27th, 2025 with the following changes. A, correct the heading and first paragraph of the order to clarify that the applicant applied for an on-site sewage facility maintenance technician's license and remove the reference to an OSSF installer and maintenance provider license to accurately state the type of license at issue in this case. And B, to reflect the applicant bears the burden of proof, amend conclusion of law number 4 to state, quote, Mr. Mewis as the moving party has the burden to prove his application should be granted despite his criminal history. 1 Texas Administrative Code section 155.4730, Texas Administrative Code sections 80.17a and 117.
I think the first side is section 155.427.
427, thank you. Do I have a second?
Second.
All those in favor say aye.
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 Okay. The motion passes. We'll hop back to.
And thank you, staff, for waiting until the end of the item, the end of agenda. We appreciate that.
Ready to move to
Yeah,
the next
you're
items?
driving.
Okay, the commission will meet in closed session in room 4222 in building F as permitted by the Open Meetings Act. Shall we say 11:30? At least 10 minutes?
Yes.
At 11:30 as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 074, to take up and consider matters pursuant to items 24 through 27 as posted and noticed.
This meeting stands in recess.
test, mic test, mic test, test.
Mic, mic, mic test, mic test.
The test.
The commission met in room 4222 of Building F for closed session from 11:38 a.m. until 12:18 p.m. on items numbered 25 and 27 as posted in notice pursuant to Texas Government Code, Section 551.074. No action was taken. This agenda stands adjourned, and the time is 12:30.